Good morning. Happy to be here in Boston today. And hello to those of you online. My name is Amanda Johnston. I'm a partner at Gardner Law, and I've been here for a little over 5 years. Previously worked in-house at a couple medical device companies. I primarily focus on healthcare compliance and regulatory strategy and submissions. So today we are going to talk about honesty and whether honesty is the best policy. So in addition to being a lawyer, I am also a full-time mother of two little boys, and I have a funny story that I wanted to share. So in the interest of kind of thinking about whether honesty is the best policy, because I say that to my kids all the time, um, I have a 6-year-old and a 10-year-old, two little boys. They're very curious. And last week we noticed that one of our phone charging cords was cut in half. And I had some suspicions as to who did it, who was the guilty party. We actually happened to have a Ring camera set up in the room, so we saw the whole thing on video. So it was like a 24-hour, investigation basically, where I was like, one of you has to fess up. It was one of you, one of the two boys. Um, and it was, I think, 20 hours into that, one of my oldest son finally said, "I did it. I'm sorry." And so we had the whole talk about honesty being the best policy. And, you should have told me, right away. That would have, been way better. You wouldn't have gotten in trouble, all these things. So it's just interesting that now we can apply this to the medical device industry and the healthcare industry when you're acquiring or involved in an M&A transaction. So just kind of an interesting parallel. So today we're going to talk about the DOJ's M&A safe harbor. We're going to talk about some of the benefits and the risks associated with the policy. I have a hypothetical scenario that we'll talk through and kind of look at the factors to consider and potential effects on just M&A activity in the industry as a whole, and then key takeaways. So the M&A safe harbor is one of several policies that the DOJ has initiated. They really want companies to raise their hand. Like I wanted my son to raise his hand right away as soon as he did something wrong. They want them to raise their hand and tell the DOJ. So it's an interesting concept, but it really is to encourage transparency. And again, kind of like what I tell my son, you wouldn't have gotten in as much trouble if you would have told me right away. So that's kind of what the policies are intended to address. So this was announced in October 2023, so it's been about a year by the DOJ. It's a DOJ-wide policy. So just some of the basics. So if you're in an M&A transaction and you're doing due diligence and the acquiring company finds misconduct, under the policy, you have to disclose that misconduct to the DOJ within 6 months of the closing of the acquisition. And that's regardless of whether you found it during due diligence or after the acquisition. So that's the first kind of timeline to remember, 6 months. And then you have to fully remediate all of the misconduct within 12 months. And if you do that, and if you cooperate, and fully cooperate, fully remediate within that 6 to 12-month range, the DOJ has announced that they will presumably decline to prosecute the acquiring company for the misconduct. There's a little bit of flexibility. There's some aggravating factors that the DOJ talks about. They also talk about, those timelines may shift depending on the conduct disclosed. So they've indicated that they want to work with companies because, again, they want you to raise your hand to kind of admit to your misconduct. Aggravating factors are, if senior leadership is orchestrating or involved in the misconduct, if there's patient harm, if the activities are egregious, or if they're pervasive, is it all levels of the company, but also if there is a recidivism issue. So if it's been an issue recurring, that could be an aggregating factor, and those aggravating factors could impact kind of the actual final result, whether you maybe get a later penalty, or they may decline to prosecute altogether. So that's the basics. So some benefits. I mean, obviously, if you comply fully, you do the 6 months, you do the 12 months, you're cooperative, you're, you know, making friends with the DOJ, you presumably will not be prosecuted. And that's the presumption of declination to prosecute. So we're looking at, more favorable outcomes for the company if there is misconduct found. There's predictable timelines. We have the 6 month and the 12 month. So at least we can kind of think about planning. Can we meet those deadlines? It could also be used to safeguard against reputational damage. So you could, proactively, you could spin it and message it such that you are, and not spin it in that way, but that you are, you're a responsible corporation. You are, wanting to help the DOJ, and you can use that kind of to prevent reputational damage by demonstrating corporate responsibility. Another benefit for kind of in-house compliance is this is another tool kind of in your tool belt to use to make an argument to invest in compliance, especially in smaller companies where they may want to be a target company to be acquired. So risks, I mean, anytime you raise your hand and say, oh, I did something bad, the DOJ could look into other areas. You have to think about what you're disclosing. They may start pulling threads and be getting into kind of lines of activity that weren't included in the original disclosure, but then kind of being added on. You can't go back. So once you raise your hand, you can't, say, never mind, actually, we're good, just kidding. So it is a final kind of definitive proactive step. And it is a presumption that they won't prosecute. It's not a guarantee. So there's a little bit of uncertainty there. And then, what happens if you discover other issues? So as you're remediating, you come across, another activity that is violative. Do you disclose that too, or do you kind of keep that quiet and remediate together? So just some things to think about when you're deciding whether to disclose. And if you don't disclose, what are the odds that the DOJ or the regulator will find it anyway? If they find it and you didn't disclose, there may be a little bit more penalty there. The whistleblower risk might be increased if everyone at the target or acquiring company kind of knows about the misconduct and you've decided not to disclose. There still may be people within the company that think that it's something that they should raise their hand on. And if any of those things happen, whether it's a whistleblower or the DOJ finds out on its own, the penalties are likely to be more severe because you can't use the safe harbor policy. So is honesty the best policy? We're going to go through some factors, but I'm going to read a hypo just to kind of give us a little bit of facts to think about. All right, so Sterling Medical Solutions, and these are all fictitious. If it sounds like anything, it was purely coincidental. Sterling Medical Solutions is a prominent medical device manufacturer. They specialize in surgical equipment, and they are targeted to acquire Precision Health Tech, a smaller company known for its advanced imaging devices. The due diligence process was like 3 days. During that process in the data room, Sterling's legal and compliance team uncovers some concerning internal documents and emails at Precision. These documents reveal a pattern where Precision has been providing incentives such as all expense paid trips and luxury items and gifts to healthcare providers, seemingly in exchange for purchasing their products and promoting them to patients. Based on the document review, it looks like this has been primarily in the regional sales team, targeting a handful of high volume hospitals and clinics. The incentives doesn't look like they have been properly documented in any agreement or contract, so it's hard to trace. But there had also been some internal whistleblower complaints that surfaced internally at Precision, which seemingly were not addressed, investigated, and kind of were swept under the rug. So despite kind of these findings, the company's reported steady growth, which made the acquisition appealing to Sterling, and the deal is supposed to close in 4 days. So upon learning of that misconduct and kind of at least getting the briefing from the Sterling's legal and compliance team, the leadership is faced with a decision. Do we proceed with the acquisition? And if we do, should we disclose under this safe harbor policy or should we not disclose? So I'll kind of go through some of the factors. So nature and severity of the misconduct. So what are the violations? With Sterling, we're looking at probably anti-kickback statute, False Claims Act. There may be others. How widespread? So you'd want to look at, is it just the regional sales directors? Is it the entire sales team? Is there any evidence that, in terms of the aggravating factors, how pervasive was it? Was senior leadership involved? Did they know? Did they kind of look the other way? All things to think about, and you may not have time to track all this down, if there's a short due diligence time frame. Is there any patient harm? Any customer harm? Things to think about. Are there any mandatory disclosure requirements where you'd already be required to disclose something related to it? That might weigh in favor of relying on that safe harbor policy. Timing and disclosure requirements. So again, there's that 6 month. It has to be disclosed 6 months after the closing, regardless of when you found it. So theoretically, you could, maybe what if you find it 5 months after closing? Then your timeline is shorter there because we're still doing this. We still have to consider the 12-month remediation timeline. Is it something that can be disclosed? Can you get, everything together and agree on what you will disclose within that 6-month window? It's a lot of work. Is it feasible to fully remediate in 12 months? Remediation can be incredibly expensive, time consuming, resources. You'd have to factor that in, those costs and timelines into the due diligence process and thinking about what you want to do. Of course, penalties. So there's potential fines, penalties, successor liabilities, kind of weighing the risks of whether it could be found out on its own or whether the DOJ could find out on their own or if there's a whistleblower risk, aggravating factors. If you don't disclose, you may have the full successor liability, whereas if you disclose and cooperate, presumably will not be prosecuted. Reputational risks. So just thinking about impacts in the market with reputation, how can that impact? It could demonstrate corporate responsibility, impact on future business. Will it impact your customer base? Will stakeholders, investors? The risk of discovery. So if you don't disclose, is it likely to be discovered? How easy is it to discover? With Sterling, or in the case of Precision, there's presumably a bunch of customers that also, receiving and were participating in this. So there may be less control over that situation that you'd want to consider. Risk management, it can be used to de-risk as a risk management tool. If a company has a strong risk management program, you can kind of control the narrative with you can attempt to control the narrative in terms of what you're disclosing and what you're proactively putting out there versus getting a CID out of nowhere and having to kind of scramble and be reactive. Think about alternative strategies. So there may be scenarios where there's misconduct found, but it's not widespread, it's limited to a team or a single practice. Companies may choose to just remediate it quietly and document it and kind of run it through their compliance program that way. So just thinking about kind of the big picture in terms of what impacts this M&A self-disclosure policy will have on the industry. And there's nothing public in terms of if anyone has actually used this safe harbor policy. So we'll have to wait and see. I'm assuming that they will issue a press release if there's a company that does use it because they'll want to use it to demonstrate how great the policy is. But it might lead to increased due diligence and scrutiny. you know, acquiring companies maybe want to take deeper looks at compliance, especially when it relates to AKS and False Claims Act violations. There might be a disproportionate impact on smaller companies who don't yet have the robust compliance program set up. They might, if you're smaller, you might be a less attractive target then. If there's a ton of remediation work that would have to go into it, the valuation could be affected as well. Acquiring companies, like I mentioned, might have a narrower acquisition focus. They may not be willing to look in certain industries where there's high risk practices. Compliance can actually be a deal breaker, and we've seen that happen. We have clients that have walked away from deals based on misconduct. It could lead to prolonged timelines with due diligence and closing. There could be some innovation stifled based on risk aversion, so not willing to take risks from a compliance perspective or regulatory perspective. That could impact innovation negatively. And then again, the post-acquisition remediation, if you have to do that, it has to be quick, focused, which is very difficult to do depending on the activities. That's taking attention away from the business activities. So that we could see companies focusing more on remediation efforts and not focusing on innovation and education and selling products. So key takeaways, this is just another policy among, I think, 3 or 4 other policies where the DOJ really is trying to get companies to raise their hand. It's good to invest early in compliance. Think about it, even if it's a small company, there are steps that you can take to at least start working towards a compliance program. We do that all the time with small companies or single companies. Understand that you're not going to have a huge compliance team, but at least having that mindset and having that be a topic of consideration. It's important. Think about this safe harbor policy before you start due diligence if you're an acquiring company. Have a discussion about, hey, what if we find something? What, maybe walk through some hypotheticals and think about what the impacts would be of disclosing or not disclosing. Because once you've identified that misconduct, that's when you have that decision. And then what would you do if you find misconduct? Would you walk away? And then what happens, to the target company after that? Are they going to have reputational damage if a deal fell through and they don't want to say why? Involve compliance from the start. So in the DOJ press release where this policy was outlined, they spoke heavily on the responsibility of the compliance officer and the general counsel to make sure that compliance has a seat at the table, at the M&A table. So there's a lot, they're putting all that on the compliance officer's shoulders to really make a seat at the table. So reiterating again that compliance is just very important, especially in M&A discussions. Proactive compliance will likely boost your valuation and maybe make you a more attractive target. And again, you can be small and still have a good, effective compliance program. And then just remember that compliance can make or break a deal. And I have a poll. So based on what we talked about today, so Sterling Medical is the acquiring company, Precision Health Tech is the smaller one. If you're on the deal team at Sterling, what would you do? Proceed with the deal, disclose, proceed with the deal but don't disclose, or walk away from the deal? And obviously there's lots of other considerations, but just curious to get you guys' thoughts. Yeah, no, that's fine. What about you guys in the audience? Would anybody disclose? I mean, it's hard without more information. I know, there's not a lot of details. I mean, it was a scheme among the regional sales team targeting a handful of high volume hospitals and clinics. Seems to be, yes. Yep. But it's intentional. And remember, they dismissed the whistleblower complaints, swept them under the rug. Yes, exactly. Yep.
You see how critical that deal is for you. It's critical, I think, option one.
Right. The closing date? Yeah. Right. Yeah, it's seemingly yes. Yep.
All right, the results online are 56% would proceed, 13 would proceed with the deal, but not disclose, and 31% would walk away.
So 50% would disclose.
56%.
Wow. Okay. The DOJ would be very happy to hear that. Yeah. Yeah, and it will, I mean, it affects the deal structure for sure. Potential evaluation.
Is it possible that you disclose to the DOJ and they will say, don't proceed?
No, I don't think they would not say that. They wouldn't direct you to take it or not. They might have opinions on that, but. Right. So then if you're thinking of like the remediation efforts, are we gonna have to fire our entire sales force and retrain? Like can we do that all in 12 months? And how much money do we have to do this? So you can see there's just a lot of considerations. I think a lot of companies would automatically, if we bring up self-disclosure with clients, they're automatically like, no, we're not, you're not raising our hand. But there may be a time and place when it is appropriate and you believe the benefits outweigh the risks. Yes. Mhm. Yes, absolutely. Absolutely. That's very true. Right.
One of the slide you had, connected to your risk mitigations,
Yeah.
and
Yep.
that was great. I think that will help with proceeding with the deal, but also mitigate the risk
Yes.
that you foresee
Yep.
there. Yeah.
Yep. I think honestly, the challenge, I think people probably would disclose more if we have examples of DOJ not like expanding the scope, and because then you're embroiled in essentially an investigation with the DOJ that you invited. You invited them to your home. So I mean, it is going to be a distraction. So if they have more, yeah, I think companies are really hesitant to raise their hand and invite the DOJ inside. So it would be interesting to see if that's how I think they could make this more viable, is just kind of some examples of how they limited their scope. They didn't go start looking for other things, that it was successful. And even hearing from a company, I've never seen, I don't know if you guys have seen a company really issue, any statement about how the process was great and they, felt they were glad they disclosed. I haven't seen that. So, I mean, you could spin that and make it a good announcement, but I don't think it's very common. That's my guess. Any questions online?
What advice would you give small startups that don't yet have a compliance program in place?
Yeah, and so I talked about that a little bit. I mean, when you're small, you have, it could be 1 to 10 employees. Understandably, you don't have a compliance program in place, but there are things that you can do. You can start thinking about policies and procedures. You can engage, if you have a friend or a consultant or a legal expert in the compliance area, there are little steps that you can take. Compliance policies, just naming someone as the person to kind of stay in touch with compliance activities, start thinking about a compliance program. It could be a part-time role or even a quarter-time role in the beginning. But just even having that documentation that you've thought about it or you've discussed it, I think those are the key things until you get big enough to, of course, if you're commercializing, then that would be a different timeline. But at the beginning, just kind of start small baby steps.